Good morning again, and welcome to our 10th lecture on the Introduction to European Law. In our previous lecture, we talked about the preliminary rulings of the ECJ. We also talked about the European competition law. And today, we are going to talk about action for annulment, action for failure to act, and the infringement procedures. What are the judicial remedies and the roles of the ECJ? Now, let's talk about the roles of the ECJ first, and then we talk about the types of procedures before the ECJ. The roles of the ECJ under Article 19 of the Treaty European Union are as follows. 1. They review the legality of the acts of the institutions of the European Union and the acts of the member states. 2. They ensure that the member states comply with the obligations under the treaty. And 3. They interpret the European Union law at the request of the national courts and tribunals in order to ensure uniformity of the EU law in all the member states. Now, what types of procedures can be brought before the ECJ? 1. The actions for annulment against EU laws allegedly violating the EU treaties of fundamental rights. 2. The actions for failure to act against EU institutions for failure to make decisions required of them. 3. The infringement procedure brought against the EU member states for not applying EU laws correctly. 4. Direct actions for compensation brought by individuals, companies, or organizations against EU decisions or actions taken by EU institutions or member states. 5. Request for a preliminary ruling when national courts ask the ECJ to interpret an issue of EU law in context in their courts. Now, in our previous lesson, we talked about how the ECJ directly or indirectly control the activities of the member states or the institutions of the EU. Now, let me repeat it again so that it will be much clearer. So, the ECJ controls the activities of the member states or institutions of the EU Union when the court directly checks on the legitimacy or the lack of actions of the EU and ends with a decision of the court. They could come to these decisions either through infringement procedure, actions for failure to act, actions for annulment, or actions for compensation. That is when we say that the ECJ are directly in control of the activities of the European member states or the institutions of the European Union. Moreover, the ECJ could indirectly control these activities when the court is requested by a national court to interpret or assess the validity of an act of the Union, or when a request for a preliminary ruling is sent to them. Now, let's talk more about the action for annulment. What is action for annulment? Action for annulment could be when a challenge of illegality of EU acts by member states, by the council, by the commission, by the parliament violates EU act or EU law. Or when you find that the acts carried out by member states or the council or the commission or the parliament is illegal, you may ask the court to annul such action or such act. Also, private individuals, in the case of acts that directly or adversely affect them as individuals, could ask the ECJ to annul such act. Thirdly, if the court finds the law in question was not correctly adopted or is not correctly based on the treaty, it may declare that act null and void. However, this action for annulment has to be brought to the ECJ within 2 months of the violation or of the breach. Now we talk about acts. What is actually an act? An act is any measure the legal effects of which are binding on and capable of affecting the interests of the applicant by bringing about distinct change in his or her legal position, could be regarded as an act. This was also established in the case IBM versus Commission 6081. It was established that any measure the legal effects of which are binding on and capable of affecting the interests of the applicants by bringing about distinct changes in his or her legal position constitutes an act. There could also be a legislative act, or acts of the council, or acts of the commission, or acts of the European Central Bank, other than recommendations and opinion, and of acts of the European Parliament and of the European Council intended to produce legal effects vis-à-vis a third party. This could be termed as an act. An act shall also, or the ECJ shall also review the legality of acts of bodies, office or agencies of the Union intended to produce legal effects vis-à-vis a third party. Standing or locus standi could be defined into 3 stages or 3 parts. 1, a privileged applicant. Privileged applicants could mean the member states, the European Parliament, the European Council, or European Commission. These 4 are regarded as privileged applicants. Semi-privileged applicants could be Court of Auditors of the European Union, European Central Bank, Committee of the Regions. These three are perceived or seen as semi-privileged institutions, while non-privileged applicants are any legal person or any natural person against an act addressed to that person or which is of direct or indirect individual concern to them, or against a regulatory act which is of direct concern to them and does not entail implementing measures like direct effects or directives. What do you mean by acts addressed to persons? It could be decisions of the European institutions towards one or more particular subjects, that is, a decision of the Commission in competition law breaches, for example, or acts addressed to another person could be acts that are addressed to, that is, a state, for example, directives to states, and shall have effect on the applicants, that is, need to prove direct and individual concern. 3. It could be a regulatory act, which is all acts with general application except for legislative acts. Direct concern. What do we mean when we say that an act must possess direct concern? We mean that direct link or chain of causations. In other words, there has to be a causality between that act and the sustained in damage. In the case of, this was established in the case of Municipality of Difference versus Commission, case number 22/83, where it was established that if there is a space for discretion of other authority, therefore, there is no direct concern. Also in case number Paraiki versus Commission, case number 11/82, it was established that there was decision that made French or France available to limit imports from Greece. Direct concern was established by the fact that the limits were imposed. So you see the difference between the first case and the second. In the first case, in the Municipality of Difference versus Commission, it was established that there is a space for discretion of other authorities, which means direct concern was not established. But in the second case, it was established that there was decision that made France available to limit imports from Greece. Direct concern was therefore established in this second case by the fact that the limits were imposed. Now, what do we mean by individual concerns? By individual concerns, the following has to be established. We also have to refer to the two mentioned cases above, the Pariaki case versus Commission, or now the Pluman case versus Commission. So an individual concern has to be very restrictive interpretation. Then in the case of Pluman versus Commission, it was established that reason of certain attributes which are peculiar to them or by reasons of circumstances in which they are differentiated from all other persons. When this is met, then individual concern is established. Also, in Pariaki case, closed class test was used. It was established that individual concern is there if there is a membership in class of person that is fixed and ascertainable at the date the measures were passed. Guys, don't worry about these cases now. It could get confusing. The duty here is just to give you a hint of these cases so that by the time you start dealing with the cases proper, it will be easy for you to understand how a decision was reached and based on why or based on what grounds. Okay? Now, what are the grounds for annulment? The ECJ could annul an act of the member state of the institutions based on the following. 1. Lack of competence given by the treaty. 2. Infringement of procedural requirements. Example, lack of consultation with European Parliament where requested. 3. Infringement of the treaty. 4. Misuse of powers. For example, adopting of measures for purpose other than intended by the treaty provisions constituting a legal base. Now, let's talk about actions for failure to act. 1. The treaty requires the Parliament, the Council, and the Commission or the European Central Bank to take certain decisions in given cases. Therefore, failure to take such actions equals reason for challenge, reason to challenge such failure to take action. 2. Who are the applicants? The member states and other EU institutions could be the applicant, and individuals or companies under certain conditions, same as the privileged applicant in annulment. We already know who is termed privileged applicants, semi-privileged applicants, and non-privileged applicants. Individuals here are non-privileged applicants, while member states and the EU institutions are privileged applicants. Are we clear? However, before filing the action at the ECJ, the applicant has to call the institution to act first or to make good the wrong that was done. You cannot just, because the act was breached, you rush straight to the ECJ to file an action. You have to call them to order, stating what your complaints are. 2 months after you call them to order and they fail to make amends, then you stand a chance to file an action for annulment in the court. If no decision or nothing was done in 2 months period, then you can bring an action. Am I clear? What are the effects of bringing an action for annulment to the ECJ. If failure to act is declared by court, two things might happen. One, the institution concerned shall take the necessary measure to comply. Two, individuals or legal persons who suffer damages deriving from the omitted action of the institution can lodge a claim for compensation under Article 340 Treaty forming European Union. Are we getting there? Now, what are the procedures of infringement? The procedures of infringement of the EU Act could be in different stages. First, it is a proceeding for failure to fulfill an obligation against a member state, which can be proposed by the Commission or by a member state against another member state. Two, the Commission can normally start this proceeding when it thinks that a member state is failing to fulfill its obligation under EU law, as empowered under Article 258 or Article 259 of the Treaty forming European Union. Even when the procedure is initiated by a member state, it is always the Commission to carry on the action. If the Commission has not delivered an opinion within 3 months of the date on which the member state was brought before it by a member state, the absence of such opinion shall not prevent the matter from being brought before the court directly by the other member state. Did we make sense here? Let me explain it again. We need to make sure things are clear. The procedures for filing an infringement action has to go through these processes. It is a proceeding for failure to fulfill an obligation against a member state, which can be proposed by either the Commission or by the member state against another member state or against an institution of the EU. Two, the Commission can normally start this proceeding when it thinks that a member state is failing to fulfill its obligations under EU law, Article 258 or Article 259. However, even when the procedure is already initiated by a member state, it is always the Commission's duty to carry on the action further. If the Commission has not delivered an opinion within 3 months of the date on which that notice of breach was brought before it by another member state, the absence of such opinion by the Commission shall not prevent that matter from being brought before the court directly by any member state. What phases does this procedure go? The procedure for infringement. 1. If the Commission considers that a member state has failed to fulfill an obligation under the treaty, it delivers a letter in which identifies the alleged violation to that state. That is, lack of transposition of a directives in due time, for example. The Commission's duty is to notify the state first or the violator And secondly, if the member state does not reply or does not comply with the request that the commission made through that letter, the commission will deliver a reasoned opinion on the matter to the offending state. If that state concerned does not comply with the opinion within the period laid down by the commission on that letter, the state may bring the matter before the court, or the commission may bring the matter before the court of justice, the ECJ. Then the ECJ will investigate the allegation and give its judgment. Are we clear? Another effect of the decisions of the ECJ. If the country is found to be at fault by the ECJ, it is required to take the necessary measure to comply with the judgment of the ECJ within a specific deadline. If the court finds that the member state concerned has not complied with its judgment within the deadline, it may impose a lump sum or penalty payment. New elements introduced by the Treaty of Lisbon includes also that the Commission can ask the payment of a lump sum or a penalty already in the first procedure or in the first proceeding. So the Treaty of European Union gave the Commission the opportunity to even demand for penalty ab initio. Are we making sense? These are the effects of the decisions of the rulings from the ECJ for or during an action for annulment. How did we do today, students? Don't worry about all the legal jargons. The court procedure is always boring, but all you need to do is take your time, listen to the tape, first time, second time. By the third time, you will grasp what we are talking about and what we need you to understand. And that should give you an edge when you start the course at your bachelor level or during your master's program, and you are guaranteed to be your lecturer's favorite because you are loaded with knowledge on how to ask him questions that are confusing you and how to keep asking him questions and how to keep the lecture fun, because when a lecturer is talking and the student is asking questions, it makes the whole lecture very fun, and I bet you the lecturer will pick interest in you, and you are guaranteed to be one of his best students. And on this note, students, we are coming to the end of our last lecture on the introduction to the European law. As I mentioned last week, I told you that in order to be able to understand this introduction to European law properly, I want to add another lecture that is going to assist you more. The lecture will be Introduction to EU Policies. I believe that when we treat these EU policies, then it will help a lot in making you understand European law properly. So our next lecture next week would be Introduction to European Policy, and it is going to be an 8 or 9 semester lectures again. And I wish you all good luck in the lecture, and I see you next week. My name is Gabriel. I'm a lawyer, and my duty is to guarantee you an A or B in your course, international law or European law or introduction to law. Eventually, we will start a new lecture for people who are going to study law properly, like criminal law or company law and others. But for now, I will see you next week when we talk about the introduction to the European Union policies. I wish you good evening and see you next week. Bye-bye.